Sometimes when you're advising landlords in connection with commercial leases, you might have unrepresented sort of startup tenants. And in those circumstances, there are precedent leases that are deliberately designed for unrepresented startup tenants. So they'll have wording that's tenant friendly, an obligation to pay service charge and rent in a monthly payment, easy in and easy out terms, etc. You can go from that extreme, a very tenant friendly, very modern form of commercial lease, to what I would class as an old-fashioned form of commercial lease that can use all sorts of old-fashioned terminology, be vast in size and very complicated in its terms. And you've got the whole spectrum of leases sitting between the two. These days, it is best to draft leases with as much clarity as possible, with as little use of archaic, old-fashioned legal language as possible, that the parties can understand and the parties can have a working relationship managed by. That seems to be the important thing. Now, before we go any further with regard to drafting leases and advising on leases, there's a bit of sort of land law that I want to share with you, if possible. The first thing to understand and appreciate that a lease has to be in the form of a deed for the lease to be a legal lease. Any lease that has a term in excess of 7 years, either at its commencement or on assignment, is subject to requirement for land registration. And as far as a lease is concerned, it is important to understand and appreciate that any lease that requires registering at the land registry must be in what's called prescribed clause lease format. In other words, it must have standardized front sheets containing all the key information that the land registry or indeed HMRC will require. Stamp duty or SDLT is payable on commercial leases, and therefore it is important to understand and appreciate that for a lease to be relied upon as evidence, for a lease to be utilised for registration at the land registry, if the lease requires stamp duty, land tax to be paid on it, it must be paid in order to be used as an evidential document or in order for it to be submitted to the land registry for registration purposes. In order for a legal lease to be created, it must be in the form of a deed and therefore must be in writing. It is possible to create an equitable lease. An equitable lease can't be registered, but can be protected by way of notice against the landlord's title. So if we have a lease that isn't contained in a deed, if we have a lease that does not have a term in excess of 7 years, provided the lease term is more than 3 years, the lease can be noted against the landlord's title. A legal lease with a term of less than 7 years does not require registration. An equitable lease of any duration does not require registration. So what other types of equitable lease could we encounter? Well, we're going to see before we finish this series something called an agreement for lease. An agreement made between commercial parties as a precursor to a lease relationship or a landlord and tenant relationship being arranged.